Hello, and welcome to Law and Democracy, a podcast of the Election Law Program at The Ohio State University Moritz College of Law. I am Tony Gaughan, Professor of Law and the Kern Family Chair in Law at the Drake University Law School, and I'm also a Senior Fellow in Ohio State's Election Law Program. I'm joined today by Professor Terri Enns, the James W. Shocknessy Professor of Law at the Moritz College of Law. Terri is also a Senior Fellow in the Ohio State Election Law Program. I'm also joined by Professor Ann Ralph, the Morgan E. Shipman Professor in Law and the Associate Dean for Academic Affairs and Strategic Initiatives at the Ohio State University Moritz College of Law, and also is a Senior Fellow in the Election Law Program at Ohio State. And Professor Steve Huffner is also joining us. Professor Huffner is the C. William O'Neill Professor in Law and Judicial Administration at Moritz. Steve is also the Director of the Legislation Clinic and the Deputy Director of the Election Law Program at Ohio State. We are joined today by Professor John Martin of the Quinnipiac University School of Law. John, before entering academia, John was a legal fellow with the Brennan Center for Justice's Elections and Government program and a clerk for a federal judge. John previously served as a research assistant professor of law at the University of Virginia School of Law, where he taught regulation of the political process and helped manage the law school's Karsh Center for Law and Democracy. John's scholarship focuses on election law, with a concentration on campaign finance regulation and election administration. Drawing upon democratic theory and quantitative methods, John's research examines whether and to what degree existing election laws advance or undermine normative democratic goals and values. For example, accountability, representation, participation, and legitimacy across federal, state, and local systems. John has published his works in numerous leading law journals and has been cited by fellow academics, federal courts, and the House January 6th committee. The topic of our podcast today is John's forthcoming article titled Unilateral Election Administration, which will be published later this year by the New York University Law Review. Welcome, John. It's a pleasure to get to interview you.
Thank you for having me.
Before we get into the details of your argument, John, perhaps we could begin with a big picture question, which is this. What is the role of a chief election official, generally speaking?
Yeah, so the chief election official is a state-level position. So in the United States, election administration is predominantly left up to the states themselves to do, and that's for elections on all levels, federal, state, and local. And at the top of each state's election administration system sits an individual called the chief election official. In 40 states, it's an actual literal individual. Usually it's the Secretary of State, but in a couple of states, it's Lieutenant Governor. And in 10 states, it's actually a cohort of individuals, typically on a group called the Board of Elections, right? A state Board of Elections. And their job, it's going to differ by state. At a very high level, they're heading the election administration process in their state, and that entails acting in a number of different areas of election administration, whether it's appointing lower-level election officials, whether it's handling voter registration and the voter rolls, ballot design, ballot access, deciding which voting equipment to use and procuring that voting equipment, providing supplies to local election officials, overseeing the counting of the vote in some states or ordering recounts, certifying elections. There's internal administrative roles, coming up with internal policies for local election officials to follow in instances where the regulations or statutes aren't clear. Being a public educator, actually reaching out to the public and informing them about their rights, about when voting day is, what they need to bring to them on voting day, how they can register the vote, et cetera. And finally, acting as a rulemaker from an administrative law standpoint. A lot of times the chief election official is given the power to promulgate rules that fulfill the statutory obligations provided to them under their state's election code. So they have a lot of power.
John, can you speak to, starting from just a big picture, what requirements are imposed on these chief election officials in the states by federal law?
So there's a few requirements, as in, I should say that there's no requirements to be a chief election official. So there's no requirements on that end as far as who could be a chief election official. There's federal law in place in some areas that limit what the chief election official could do. So, for instance, in 1993, Congress passes something called the National Voter Registration Act. In that, it contains a few provisions directing, providing some limitations on chief election official powers. So, for instance, there's something called the 90-day quiet period provision, which prevents election officials from engaging in systematic deregistration of voters within 90 days before the election. Election officials are required to turn certain agencies into voter registration agencies. So a lot of us know the DMV. We're allowed to register to vote there. That's because of a federal law imposed by Congress. Under the Help Americans Vote Act in 2002, chief election officials are required to maintain a statewide voter registration database. So federal law imposes some requirements on chief election officials, but really it's in a few limited pinpointed areas, and a lot of the authority and the limitations that are that our chief election officials are subjected to come from state law.
So, John, you listed off a lot of roles, from appointments and voting machine purchasing and all of that. Out of that list, are there areas that you think are more problematic by having a unitary chief, one person up at the top, and others that are much less problematic?
Yeah, so I'll first start with a few problematic areas, and with the caveat that the concern is not so much that most people in these roles are incompetent or abusing it. The concern more so being, well, what happens if someone does hold this role that is either incompetent within their role or is using their powers with partisan intent in mind, right? So with that in mind, one area that really stuck out to me looking at all these powers that chief election officials has, it relates to ballot design, and specifically state ballot measures. So and this is such a specific thing, but it's a good example of where like true authority is held by many of these officials. So in states, a lot of states, citizens could put through a petition, they could have direct democracy ballot measures put on the ballot, right? Where the citizens themselves vote on whether they want to create a new law or amend the law. And in a lot of states, so first off, a lot of ballot measures are very lengthy in the actual law that we're trying to pass. So to get on a ballot, you have to abridge it, you have to summarize what the law is going to say. And in many states, it's the chief election official has either sole authority to approve of that language, or at the very least governs and has predominant control over a committee that has to approve that language. We saw this a couple of years ago in Ohio. There was in Ohio itself concerns about how the word on the ballot and describe a ballot measure trying to create a more independent redistricting commission, if I remember correctly. And the Secretary of State, I think, obviously didn't like that ballot measure and worded it in a way that made it sound like, actually, if you vote for this, you're voting to further enhance partisan gerrymandering. So people voted in a way, based on the way that the Secretary of State worded the ballot measure, opposite of what they might actually, the way they would have voted, right? Another area is voting equipment. chief election officials are oftentimes, they have the final vote on which equipment to adopt, which voting equipment to certify. So like voting machines, tabulation machines, which equipment to decertify. We saw post 2020, when the Stop the Steal movement starting to grow, officials running for these offices, in a few cases winning these offices, where part of their platform was, I'm going to use my power as chief election official to require more hand counting of ballots, right? To decertify or get rid of voting equipment, right? And in a lot of states, they actually have the power to do that. It's not that they're overstepping their authority. The buck stops at them. Sometimes they have to consult with like third parties, supposed neutral third parties, but a lot of times they themselves get to choose those third parties. So those are two that stuck out as problem areas. One area that I was actually surprised that the chief election official doesn't have as much authority was in certification of results. I think post 2020 there was a lot of concern that could these roles be used to prevent the certification of elections that let's say the chief election official or the governor, they don't want to certify someone winning an election because it's someone from the opposite political party. But a lot of times the statutory language is worded in a way that requires the chief election official to certify the results of the election. It's never like something that they can or can't do. It's required. And then there's a legal process in place, right? If the chief election official doesn't uphold that obligation on their end.
John, some of the activities that chief election officials perform that you've just described as potentially more problematic are reasons that many people for many years have unsuccessfully argued that we should scrap a unitary chief elections official and instead move to election boards, where it would be maybe harder for one to manipulate ballot language, for instance, or to decertify equipment for partisan reasons, for instance, to take on a couple of the things you mentioned. And I take it you're not arguing, you're not trying to join that fight, which, as I said, has not been very successful, even though there are plenty of other democracies around the world that don't rely on unitary election officials the way we do. And that instead you're wrestling with ways to improve a system that continues in the main to rely on these chief elections officials, most of whom are chosen through partisan elections in the first place. So I'd love to have you now tell us a little bit more about what you see as the best ways to refine that unitary election official system that most states have.
Yeah, you're right, Steve. I'm meeting the system where it's at. So as I said earlier, 40 states have a unitary chief election official. So it'd be very difficult to convince all those states to move to a state board of elections, even if we might view that as a little bit more of a safeguard against unilateral abuse of the position. So my paper examines what we could do from a lens of accountability, right? Democratic accountability. What do we do to prevent misuse or abuse of an office from occurring? Well, we try to enact a system that holds the holder of that office answerable either to people or to some principle, right? Something beyond their own personal whims and their own personal desires. Something that makes sure that it's not just one person overtaking the role and acting in a capacity that frankly fails to properly uphold the democratic process, right? So what I saw when I was going through the election codes and thinking about what modes of accountability currently exist, it seems like the way we presently hold chief election officials accountable, the main methods we rely on is electoral accountability, in that in most of these states where we have unitary election officials, 33 out of 40 states, the chief election official is elected by the people. Or at the very least, what we might call like indirect electoral accountability, quasi-electoral accountability, where in these other 7 states, they're appointed by a governor or a legislature, so they're appointed by elected officials. So election seems to be like the big one. Other than that, we rely on what I call, or what the literature calls, legal forms of accountability. So you're not just answering to the people, but answering to some legal norms, legal principles, statutory and constitutional limits. And that happens to a degree right now, in that a lot of people will sue their chief election official if they think the chief election official is misbehaving. I call that in the paper an ex post form of accountability, in that we're trying to remedy the wrong after it's already occurred. My paper doesn't say that that's necessarily wrong, right? And that we shouldn't have that, because we should have these mechanisms. If a wrongdoing has occurred, then after the fact, we should try to remedy it. But I try to move, what I'm arguing for is to move us towards what I call ex ante legal accountability. So using the law in a way to prevent or mitigate the possibility of wrongdoing in the first place. And then also adding in a third form of accountability away from electoral and legal accountability, called internal accountability, which is relying upon individuals actually within the on the executive side, either within the chief election official's agency, something like called vertical accountability. So being accountable to perhaps local chief election officials, right? Other people within the election administration apparatus, or horizontal accountability, where they're accountable to other executive actors, like a state attorney general. So that's very high level. I could get then into the details of those two areas, or if you'd like.
Yeah, John, I'd love to hear more about these ideas of ex ante mechanisms for accountability. We are all lawyers, and we often think that a lawsuit is the best remedy for wrongdoing. It's kind of a hammer and a nail problem. But I was really intrigued by this proposal for ex ante mechanisms of up to ensure accountability. So I'd love to hear you just speak more to that one.
Yeah, absolutely. So yeah, the lawsuit, I mean, look, like it's never going to go away. There's problems with it, though. It's expensive. You need to find a plaintiff. You have standing issues, especially on the voter side. Maybe not so much on the candidate side, post v. Illinois Board of Elections, which just came out earlier this year. We had the Purcell principle, right? We have all these the politicization of the judiciary, right? So ex ante would look something like, there's a few options that throw out there, right? On the legal side, right? Something like state level preclearance, right? So we all think back to the Voting Rights Act and how we had federally mandated preclearance for certain jurisdictions that had problematic histories, right, in the voting rights area, requiring a judge or the attorney general to sign off on a change in voting practices in that state. Now that was struck down, right, for federal reasons. But on the state level, right, preclearance very much remains a possibility, right? And I'm not arguing for preclearance for every single possible action that a chief election official would make. But how about any action that might implicate the voting rights of a significant number of people, right? So, you're going to remove 100,000 people from the voter rolls. Maybe we need to have a judge look at that before we allow that, because that's a huge amount that's a very impactful decision, right? And in fact, it affects potentially the voting rights of thousands of people. So preclearance for decisions that I say would affect to a very high degree the substantive rights of voters, and you could always quibble over what exactly that means in the details. And I try not to be overly prescriptive, right? Because each state's different. You could also impose qualifications on holding the office, right? So go even further back and try to make sure that those who are entering the office are actually qualified to hold it. Now, what that looks like, again, you could debate. I would argue maybe having a certain amount of years of practice as an election official on a lower level, either locally or within like the state's Department of State, making sure that no one's going in that office that is totally unqualified, right? Someone who clearly cares about election administration, that's something that they take pride in doing well. Internally, an ex ante form, well, one, you could have internal preclearance as well. So you could require like a state attorney general to sign off on certain actions by the chief election official. And a few states do have that in certain instances, right? The state attorney general needs to come in. The problem sometimes with that is that those offices are also politicized, depending on the state. But going back to that vertical form of accountability, how about let's get local election officials involved? Oftentimes, these are individuals who are less partisan, at least in their actions. They're individuals that go into these roles because they just care about having a good democratic process. And maybe we'll have like a committee of local election officials that reviews certain actions, right, by the chief election official. Maybe we put in place dispute resolutions where if a citizen themselves is concerned with an action that the chief election official, let's say they're planning on doing, right, or and this might actually go towards ex post accountability, but I also advocate for ex post internal accountability because we don't really have much of that at all. But allowing citizens to step in and file complaints if they think that the chief election official is engaging in wrongdoing, and then having a dispute resolution play out internally, right, on the internal executive side, which does happen to a slight bit. And I think you had Rebecca Green on many weeks ago to talk about this exists under Help Americans Vote Act to some capacity. So those are like, there's more. I don't want to keep talking, but there's ways in which we could rethink accountability that at the very least adds on to our current methods, creates a broader web of accountability, and moves us past what I think is a weaker form, which is certainly electoral accountability. I think is a weaker way of holding the chief election official accountable. And lawsuits are hit or miss, right?
John, your article talks both about the possibility of giving the unitary chief elections official less responsibility, less authority. Talk about that in terms of decentralizing, and so moving some of the authority down to more people at more localized levels, as well as, in a certain but different sense, limiting their authority or their discretion by adopting stronger conflict of interest rules. And I took it that you were in favor of conflict of interest strengthening, and not so favorable or mixed about pushing responsibility down and giving the unitary chief election official less authority. But I'd be eager to hear you just talk a little bit more about whether we do have too much responsibility in one person right now or not.
Yeah. So certainly, I'm glad you mentioned the conflict of interest rules. That's another potential ex ante form of accountability. A lot of chief election officials oversee their own elections because they're elected officials. We probably shouldn't allow that, right? I think that's a pretty easy, quick fix on that front. The question of centralization versus decentralization is tough for me because you could argue both ways. So one instance where centralization might have actually been a plus is during COVID, right? Where we suddenly had this nationwide pandemic. We never, at least in the past 100 years, in living memory, had an election during a pandemic where people were staying home, right? We had to figure out how are we going to have a functioning election, right? A functioning electoral process. And in many states, so my home state of Pennsylvania, right, for instance, it was the chief election official who was able to put out policy statements instructing lower level election officials, election workers, right? What are we to do, right, with the law as currently written, right? The law that was not written with a pandemic in mind, but how do we adhere to our statutory obligations when we're trying to run elections, while also accommodating the fact that we have a giant pandemic, right? And having one individual at the top with that flexibility to call that shots and have that much authority over internal administration was a good thing, provided you had a good person in the office, which most chief election officials are good, right? Granted, most of them are. But at the same time, when you decentralize it, you are putting in place insurance that this changeover, this office that changes every 2 or 4 years, it doesn't have such a potentially dramatic impact, right? because it's harder to fully assume the office. I mean, assume control over this process, right? If those on the bottom. So the answer, I don't know. Like, I guess you could look. One way we could think about it is maybe we look at all these roles that the chief election official has and think, where is it that it's actually a strong suit to have the unitary chief election official have more of the power? So something like internal administration, I'd say potentially so, right? Something like controlling the actual statewide voter roll, maybe. Although even now, there's like still like local election officials are also very involved with who's on the voter rolls, right? But when we think about something like public education of voters, something like procuring voting equipment, right? In some states, especially for voting equipment, in some states, local election officials actually take the lead on that anyways, and it works just fine, right? Because they know what they need, right? In their precincts, right? They know what they need. They know what they want, right? So maybe it comes. Sorry, this is a bit of a non-answer, but maybe like going through these different roles, if we want to try to figure out, well, how can we make it so this isn't some all-powerful office? And not that it is in every state; it depends on the state, right? But to try to make it less centralized on this one figure, it could be interesting to look at all the different areas they work on and like what are some areas where actually it would be a local election official strong suit to take some of the reins on this. I mean, that's how I go about it if I start to delve more into it. And you're right. My paper meets the system where it is, right? And the fact that we do have a highly centralized office that controls elected administration in so many states.
John, are there states that do a better job than other states of holding their chief election officials accountable to democratic principles and values? Are there models we can look to?
Yeah, so there's a few. I mean, each state does things differently, and I feel like I'm saying this a lot, but like there's certain areas, forms of accountability I advocate for that are done well in certain states, right? So Michigan, for instance, has I think it's called a board of state canvassers, which is a very much, I don't want to say independent, but it's a bipartisanly chosen body. It's not elected. It's chosen by, I believe, elected officials that are like evenly made up of Democrats and Republicans. And they're put in place to act as a stamp of approval, right? A final say on certain actions by Michigan's Secretary of State, mainly in the area of ballot design and voting equipment procurement. So the Michigan Secretary of State, not that the present Secretary of State we have, Secretary Benson would do this, but if you have a secretary who in Michigan who's trying to, let's say, just refer all the way back to hand counting of every ballot because they're very conspiratorial and think all voting equipment is bad. They couldn't do that because you have a board of state canvassers in place that would have to sign off on that, right? I'm trying to think of another state. There's certain states where how do I put it this way? Where those who have to sign off on chief election official actions, because so a lot of times you will have this independent board. There's certain states where the selection of that board itself is done in a way that I think is actually fruitful. So the people who are selecting those on the board that approves of the chief election official's actions themselves are bipartisan, right? They're creating a board that isn't just going to like bow down to the chief election official's actions. At the same time, and not that you asked me states that are doing it poorly, but if I could, in Ohio, not to keep picking on Ohio, theoretically there is a board in place that is supposed to provide approval, I believe, over selecting voting equipment. It's something regarding selecting and procuring voting equipment. And it's a 5-person board, but as it turns out, one of the persons on the board is the Secretary of State themselves, the chief election official, and then they select 2 of the 4 members, right? So they essentially get to create a majority right away on that board. So it's not actually an effective form of accountability. One perhaps controversial form of accountability, maybe I'll raise this just as controversial, but Pennsylvania is the only state I was able to see that for very egregious violations from the chief election official side, imposes actual criminal liability on chief election officials. I can see why that's a hit or a miss, because you don't want to scare people away from these positions and say, well, if you mess up, you might be on the hook criminally. But I think the mens rea there was like, if you're knowingly like disregarding your actions, like it was something to do with behaving in a very corrupt manner, you could face some criminal penalties. I actually kind of like that when I saw Pennsylvania. I don't know what your all thoughts on that would be, but for an office of such significance, I thought that was really important. There's states that have one last thing. There's states that have state voting rights act in place. There's 9 states that do, and a few of them have pre-clearance requirements in place over voting practices. I am admittedly not. I'd have to look deeper into which ones that might extend to activities by the chief election official themselves. But when it comes to, at very least, to regulations imposed by the chief election official, I imagine that would count as like a voting practice. That at least that's how I write pre-clearance, right? So I know those are like tiny little examples, but those are a few that just popped into mind. I think a lot of states haven't thought too deeply about holding these offices accountable, so there's actually not there's some accountability in the law in each of these states, but in many of these states there's not as much as I would have liked when I was looking, which is why sometimes I'm struggled to even find an answer to that question, Tony.
So, boy, there's a lot there to keep working through. I'm inclined to think that most states would have some way of bringing criminal charges against a Secretary of State who was truly knowingly doing something untoward, even if it's not in their election code. There's some
Yes,
other
sure.
more generic malfeasance in office kind of thing.
Yes.
But I don't know that area. But in terms of states that are behaving well, or that have accountability mechanisms in place, I should say, you mentioned the Board of Canvassers in Michigan as potentially worth emulating. And then I wanted to invite you to say a little bit more about how having a Board of Canvassers might compare with having pre-clearance requirements, because a Board of Canvassers could perform a very similar function for certain things, just depending on how it's structured.
Yeah. So this is where I think internal pre-clearance has a bit of a leg up over judicial pre-clearance, in that in internal pre-clearance, when we're assigning people in a more administrative function, a lot of times these are individuals who have expertise in the area, right? These are individuals who specifically have specific professional knowledge about election administration, or at the very least, even if someone's assigned to that role who might not have come out of an election administrator role, in the fact that that role focuses like exclusively on election administration, they'll learn very quickly, right? What is and isn't allowable. Whereas judicial accountability, like legal accountability via the judiciary, not that judges can't do great jobs with it, right? It's just that a judge is very generalist in everything that they're focusing on. Plus, at the same time, then you're potentially adding, one, a burden on the judiciary, and two, I think people might not. I don't know if it's like, maybe I just have Shelby County in mind and how I think about how like people might think about judicial preclearance. But I imagine judicial preclearance might look like a less popular, almost like the court usurping authority over state executive officials, whereas internal preclearance feels more like it's natural, right? It's the executive checking themselves, right? And it's individuals who have actual closer authority and knowledge on the area that they're pre-clearing.
John, one thing that really stood out to me in the article was your statement that even seemingly procedural tasks that the chief election official completes can end up having substantive effects on voters. And as I'm hearing you talk today, you've gone through a lot of different examples of actions that chief election officials could take that might seem to the casual observer, whether it's listing names on a ballot or purchasing voting equipment or preferring hand counting over electronic tallying, might seem like sort of neutral in terms of their impact on voters. So I'd love to just have you lay out a little more for folks who might be interested in this, in what ways those seemingly procedural choices, I mean, I'm old enough to remember the butterfly ballot design, but in what ways can those choices that might seem neutral actually affect substantially the outcomes of elections?
Yeah, so there's and as it's discussed in the paper, a great example of ballot design, how it could play out in, is it Broward County, Florida? And not that I will confess, I don't know if it's the Florida Secretary of State who made this decision, but it's still a very poignant example of how these decisions can have an impact. In a certain county in Florida during the 2018 U.S. senatorial election, well, the 2018 general elections in general, but there was a U.S. Senate race there. Rick Scott, I think, was running. The ballot for individuals in that county, to vote for the U.S. Senate race, those particular candidates were put on the very bottom left side of the ballot under all the ballot's instructions, whereas all the other candidates for all their offices were put to the side of the instructions, to the right of the instructions, and a lot more visible. So if you're reading through this, let's face it, a lot of people skip over the instructions for these things, right? So they might take a glance and they say, oh, all the instructions on the left side, gonna skip over and gonna look at all these races on the right side. A lot of individuals didn't fill out the U.S. Senate, like the bubble for the U.S. Senate race. Even look, if you have a few people that do that, you might just think, well, maybe they just didn't care about that race. It was 25,000 individuals in that county did not vote in the U.S. Senate race. Very much statistical anomaly, and I think we could chalk up to the fact that the ballot was designed poorly. And I don't even know if it was necessarily on purpose, right? That could have just been accidental, right? People weren't thinking it through, but it had a major impact because in that particular election, Rick Scott won by less than 10,000 votes, right? So, and it was a very Democratic county. So who's to say if that ballot had been designed better, would the Senate race have changed? Would the results have changed? Potentially. And look, these are areas. It's not in every state. As I said, like in some states, it's local officials or it's a committee of individuals, or sometimes even if the chief election official has authority, it's limited. Like there's still certain rules they have to adhere to. But there's still states where we have a unitary chief election official making these decisions, right? And what if they want to deprioritize like a certain race, right? Who's going to stop that, right? I suppose the candidate themselves can sue, but it's one of those things that just you might not even think about until after the fact, and then you're like, oh wait, this ballot was designed very poorly, and now we have these election results that we're dealing with.
John, I'm wondering about a potential federal rule here. As you so clearly explain in your article, we have such a decentralized political system, and there are clear limits on what Congress can do, particularly with regard to state elections. But are there ideas for how Congress, perhaps under its elections clause power, where Congress could enact some laws that would provide for more accountability for chief election officials, at least with regard to the administration of federal elections? Are there ideas that you have for what Congress might do if Congress was willing to move into this area and exercise its authority, limited though maybe under the elections clause?
Yeah, so that's a great question, Tony. And I must confess, I haven't given this question as much thought as I should have, mainly because I don't foresee Congress in the near future actually enacting laws, at least laws that I would advocate for. It's not lost to me that a few days ago Trump called to nationalize elections, right? Presumably through the elections clause power, which gives Congress the ability to pass regulations regulating the procedural aspects of congressional elections, right? if I were to just wave a magic wand, a couple of things I might put in place, and it's hard to, because you have to do it through the lens of, well, we're regulating congressional elections, which sometimes has like an effect then it just applies to all elections because states don't want two different systems, right? When they're administering elections. Perhaps putting more limitations on the deregistration of voters. We've seen instances where chief election officials will wipe out like hundreds of thousands of, we saw in 2018 in Georgia, then Secretary of State Kemp, who was running for governor at the time, wiped off like almost 600,000 voters from the voter rolls, right? Perhaps more limits in place. We have a few, but more limits on those actions. I'm wondering if you could, I mean, one of the big things I really want to advocate for, I think would make a difference, even if it seems small, is imposing like mandatory, like certain qualification requirements on chief election officials. Could you make an argument for that under the Elections Clause power? Perhaps, in that chief election officials are mandated under federal law to do certain things, like maintain a statewide voter registration data. Like in some, like the chief election official, state chief election officials are mentioned in federal law. So maybe you could say any chief election official overseeing congressional elections has to have like 5 years of experience in like the election administration space, right? Something small like that. I don't know, requiring a truly independent body to oversee certain actions by the chief election official related to voting equipment, right? I mean, with a lot of these laws, the way you can use the Elections Clause is to say that it applies to federal elections, right? So you could say any voting equipment procured to hold federal elections must be signed off by an independent committee, right? So this always goes back to, I think, a lot of like, I know sometimes I think I'm repeating a lot of the solutions I'm saying, but I think you could write it in a certain way where you could get the Elections Clause on your side, right, and enact federal limits, right, or federal accountability mechanisms. But again, I don't foresee it happening anytime very soon. I would like to be wrong on that, but I don't think there's the political climate, which is why I think a lot of this change is going to have to happen on the state level.
I know we're almost out of time, but can I ask one more question that to me connects to that, which is to ask what you think about the possibilities of state reform in the Michigan model. I mean, how realistic, taking the field as it lies now, how realistic is it to imagine many more states having something like a board of canvassers that are acting as an internal preclearance or some kind of constraint on a unilateral chief?
Yeah, well, I certainly don't think it would be an unpopular idea. I think we see, to provide an analogy in the area of redistricting, a lot of people, it's very like bipartisanly popular to want an independent redistricting commission, right, to oversee redistricting. So we can imagine you can make the same argument to individuals that, well, this is of highly influential office on the democratic process, and it could be good then to have an independent body that oversees a lot of the very important decisions on the end. I think, like, would state legislatures go along with it? Again, maybe. I mean, again, we see state legislatures that are in favor of putting in place, in certain states at least, in putting in place independent redistricting commissions, right? So I don't have like a good read on like the actual political appetite now, but I imagine if I were to guess, there would be a lot of appetite for that sort of, especially these days. Like these were relatively like boring offices, I think, that people didn't pay attention to prior to 2020. We had Bush v. Gore, right? We had Bush v. Gore, and Florida's Secretary of State became a news story. But other than that, up until 2020, people largely ignored these offices. But now that I think there's a lot more attention on them, that's why I'm writing on them, right? I think we realized over the past few years that we need to take these offices more seriously. So I think you could rally a political movement to enhance the law, enhance accountability, right? Pass new laws that change and hold accountable the chief election official to some sort of higher principles, right, rather than like overt partisanship.
I'm afraid we are out of time. I'd like to thank John and my colleagues for a fascinating discussion, and we look forward to having you, John, on the program again in the future. To our viewers and listeners, I'd just like to remind them to please like and subscribe to our Law and Democracy channel and be on the lookout for our next episode on YouTube and Apple.
Thank you all very much for having me. It's a pleasure. I can't wait to be back.